5 seconds to go. Start. The basis on which it has been urged that suit 4 is not a suit for possession is that this court has held in Deokar versus Shio Prasad Singh that where property is custodial legis, it is not necessary to make an independent prayer for the delivery of possession. Stop. Hence, it has been urged that since a specific prayer for seeking possession was not necessary, prayer B is OTOs and the character of the suit must be adjudicated only with reference to prayer A. Stop. Para. The submission cannot be accepted. Stop. The decision of this court in Deokar lays down that where property is custodial legis, it is sufficient to seek a declaration of title. Stop. This is because the court receiver, who is an officer of the court, would hold the property for the party who is found, upon adjudication, to be entitled to possession. Stop. Since the receiver would be duty bound to hand over possession to whoever is held by the court to be entitled to the property, a formal prayer for seeking possession is not necessary. Stop. But what this submission misses is that a suit seeking relief of possession has not been held to lack maintainability. Stop. A declaration of title suffices because once property is custodial legis, possession would necessarily follow the grant of the declaration upon the adjudication by the court. Stop. The relief of possession is therefore implicit. Stop. To hold that a suit of this nature, while the property is custodial legis, cannot possibly be held to be a suit for possession is therefore a submission which has no valid basis. Stop. Para. The submission that suit 4 is barred by limitation is founded on the following hypothesis. Para. The entire property which is the subject matter of the suit was custodial legis consequent upon the proceedings under section 145, Once the property is custodial legis, a suit for declaration would suffice and there is no need to seek the relief of possession, Prayer B seeking a decree for the delivery of possession, if it is considered necessary, is redundant, and consequently, in the absence of a prayer for possession, the suit is only one for declaring the character of the mosque and is hence governed by Article 120 of the Limitation Act 1908. Stop. Para. The basic foundation on which the above submission is based is that the entirety of the property comprised in the inner and outer courtyards was custodial legis and was under the protective attachment of the receiver. Stop. However, as a matter of fact, on 18 December 1961, when the suit was instituted, only the inner courtyard had been attached in pursuance of the orders passed under section 145. Stop. The outer courtyard was placed under receivership only in 1982. Stop. In suit 4, the property which was the subject matter of the dispute was, the inner courtyard which had been attached under section 145, the outer courtyard which had not been attached, and the adjoining graveyard which had not been attached. Stop.